You're listening to the Bail in the Midwest podcast.
Hello and welcome to the inaugural episode of the Bail in the Midwest podcast, where we explore a variety of topics related to bail, pretrial release, and the criminal justice system in the Midwest. My name is Shane Rolf. I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 35 years. Today, we'll be discussing bail reform. We hear about bail reform in the news seemingly every day, but bail reform is a pretty vague and broad topic and means different things to different people. The Biden administration's version of bail reform, as part of its campaign platform, advocated the elimination of cash bail, claiming that cash bail was a modern-day debtor's prison. While on the conservative side, some try to claim that we can save lots of government money by releasing people from jail with little or no assurance that they will ever return for trial. In California recently, legislation passed essentially outlawing financial bail and requiring release for virtually every type of crime. The actual voters of California ultimately overturned that decision, but the California courts have continued to increase releases. New Jersey, under Republican Governor Chris Christie, functionally eliminated its bail bond industry, replacing it with a risk assessment algorithm that could supposedly predict who would appear and who wouldn't, and adopted a system that released most defendants without any sort of bond and created a type of preventative detention where certain defendants couldn't get pretrial release at all if they failed this new risk assessment. So to some, bail reform means release everyone, because criminal defendants are the actual victims of an oppressive criminal justice system, whereas others view bail reform as a chance to deny even the option of bail to certain defendants. So, are either of these positions correct? And how is bail reform, however it is defined, beginning to impact us here in the Midwest? Today, we have two guests who have unique perspectives on this topic. My first guest we'll introduce is Stephen Owens. And Mr. Owens, if you could give us a little bit of your background and your experience in this area.
Yeah, sure. Thanks for inviting me on, Shane, and everyone. So first off, I have been in the industry for better than 20 years. Started my company straight out of college and have grown to a large general agency throughout the state of Kansas. In addition to that, I am blessed to serve in the Kansas legislature and have been there for, we're wrapping up the fourth session that I've been part of. Currently sit as chairman of the Corrections Juvenile Justice Committee, as well as sitting on Judiciary and Appropriations. So I have a lot of involvement in the criminal justice system. I also served as the vice chairman of the Kansas Criminal Justice Reform Commission that worked for better than 3 years on criminal justice reform matters. So certainly have a perspective from both sides of the argument and look forward to discussing those with you.
Great. Thank you very much, Stephen. And also John Barker, who is also in the Kansas House. Mr. Barker, if you could give us a little bit of your background. And I know you have additional background in the criminal justice system besides simply being in the legislature.
Well, thank you. I do have some experience. I spent 25 years as a judge with the district court, the 8th Judicial District, which has 4 counties: Gary County, Dickinson County, Marion County, and Morris County. And on my retirement, in 2012, I ran for the Kansas legislature, and I've served on, formerly I was the chairman of the Judiciary Committee. I've also presently serve as the chairman of the Federal and State Affairs Committee, which deals with mostly state public policy. It's an exempt committee. I also serve on the Kansas Sentencing Commission that will, for the last 8 years, I believe. I've served on that. So that's my background. And prior to that, many years ago, I was in law enforcement.
Excellent. So it sounds like we have two people who really do know their stuff on this particular topic. Stephen, I'd like to first turn to you and kind of give us just kind of a broad overview of what is bail, so we kind of know what we're talking about here.
Sure. Yeah, happy to do so. So, bail, we are uniquely charged in the federal and state constitution as having the right to bail. And each one of them reads a little bit differently, but uniquely and simply put, Bail is the security of somebody being released and the surety that they will return to court. So ultimately, when somebody is charged with a crime, there's probable cause for that charge, but obviously you haven't been convicted yet, so you haven't been found or adjudicated guilty. And what bail does is it secures your appearance. So it is the promise that is made to the court that says you're going to come back each and every time until your case is adjudicated, and in many instances, even until you're sentenced in that crime if you're found guilty. So there are a number of different ways, of course, that bail is posted. We'll take a simple DUI charge in maybe a local court where you have $1,000 bond that is charged. In some courts, they allow you to post that bond as your own recognizance, more of kind of just a promise to appear. But then in others, they require you to post $1,000 bond, and that can be done, of course. If you have that $1,000 in cash, well, you can certainly post that bond yourself. Many people don't have that amount of cash hanging around, so that's where they reach out to a bondsman that then posts that guarantee on their behalf and makes that bail then affordable by only charging 10%. That bondsman is then, of course, then charged with ensuring that that defendant returns each and every time. And in the event that they do not appear in court, they have an obligation from the court then to locate that defendant and return them to custody. So simply put, a bond ranges from, there's some courts that are as low as $200 or $300 bonds, all the way up to $1 million bonds, depending on the severity of the crime, because everybody inherently has a right to bail. So that's kind of a very simplistic overview of the bonding system. Certainly plenty of nuances, different types of bonds, things like that. But that should sum it up pretty easily.
And that sounds pretty much like I've had it noted here that bail was a mechanism for allowing people to accuse people to be out awaiting their trial, but still go about their lives. Does that sound about right to you as well, Judge?
Yeah, I mean, you're absolutely right. The idea again is you haven't been proven guilty, so you should have the ability to be out pending trial, to seek representation, to be able to pay your bills, take care of your family, and handle your affairs pending the outcome of your trial.
Sounds good. Now, do either of you, I know that the state of Missouri, for instance, the Supreme Court has adopted some rules there that press for a much more lenient release system, or you have to jump through multiple hoops before you can actually require some sort of secure bond in the state of Missouri. Do either of you have any experience with that beginning to occur in the state of Kansas?
Well, I think I do. I'm going to go back to 1987 when I first went on the bench. It was really subjective on the part of the judge to set the amount of bond. Normally, we would set the bond when we signed the warrant for the arrest. Of course, after the arrest, they make a first appearance. At any time and at any proceedings, the defense can raise the issue of bond to either have it reduced or eliminated entirely. Second occasion would be after a preliminary examination on a felony case. They can again raise the issue of bond. What's interesting is the 8th Amendment to the Constitution, United States Constitution, says we would not accept excessive bond. There's always been a presumption in the Constitution that there should be a bond to ensure people appear in court. But over the years, bonds have changed. We put more conditions on bond. We may set a surety bond with a condition of, if, for example, like a domestic violence case, that they not have any contact with the alleged victim in the case. We also have a standard condition of bond is not to consume any alcoholic beverages or illegal drugs and subject to a urinalysis test. We also have conditions such as you must have an ankle monitor along with a surety bond. So those things have changed, but I think it was probably in the 90s, the 3rd Judicial District, which is Shawnee County, the chief judge initiated a program where the bonding was done through the court system. They would post her 10% with the court system and have court services. The state Supreme Court later found that to be unconstitutional. courts do not get into the job of bonding. That's a business. So they found that. And so since that time, we rely on bail bondsmen. Bail bondsmen have to come in every year to the court, each judicial district, and establish that they have sufficient funds in accounts that can cover the bonds that they write. I know there's 4 states, I believe 4 states. Kentucky is one of them. Wisconsin, I think, is one. Can't think of the other 2 that have eliminated bonds and made bail bondsmen unlawful. It's interesting. Their failure to appear rates have went up dramatically. So that's my background, and from and now that I still act as a judge on occasion when I'm not in session. So they've encouraged us to do away with cash bonds because they think that it's unfair. So we use mostly surety bonds or OR bonds, which is the own recognizance bonds. So it is moving, but the important part is that it saves counties and state money. When someone does not appear that we have a surety bond on, we contact the surety company or the bondsman, bonding agent, and give them an opportunity to bring the defendant to appear in court. And if they fail to do so, then of course the bond is forfeited to the court system. So, and it goes to the state general fund, or if it's it depends on what court it is. But that's the big advantage of having bail agents, because if not, the counties have to send their deputies out to try to find them. And if they're in another state, then they have to go to the other state, transport them back to the state and hold them. And if we didn't have a bonding system, we'd have a lot more people in jail.
Mm-hmm. Shane, if you don't mind, I might just jump in here on this, only to mention that, you know, the Ninth Amendment in the Kansas Bill of Rights is different, right? So the U.S. Constitution basically says excessive bail shall not be required, nor excessive fine imposed, nor cruel and inhuman punishment inflicted. However, in Kansas, Section 9, it says all persons shall be bailable by sufficient sureties, except capital offenses where proof is evident or the presumption is great. And then it goes on to talk about excessive bail. So it's interesting that the Kansas Constitution specifically calls out sufficient sureties as being part of the bail process, whereas our federal Constitution doesn't.
Correct.
Well, and that was actually another one of my talking points here was both the U.S. Constitution and the Kansas Constitution provide some of those guarantees towards bail. As you noted, the U.S. Constitution only guarantees non-excessive bail, and unfortunately, the Supreme Court has determined that zero bail or no bail at all, preventive detention, is not excessive. But many states like Kansas have the requirement that in their state constitutions that you be bailable by a sufficient surety. Presumably that means a third party who will stand good for the amount of the bond if you don't show up for court. I mean, that process is, dates back to the Magna Carta. And in theory, you would think that this is there to prevent the government from engaging in preventive detention or de facto preventive detention without at least giving the defendant some sort of option to secure his freedom pending trial. Now, I'm a little out of order because I want to talk about how if bail reform is increasing crime, and as you might imagine, I think it is, but we'll talk about that in a second. But as crime does spike as a result of this sort of reform, are we in danger? Because we've seen this happen in both New Jersey and New Mexico where the constitutions were altered. Are we in danger of potentially losing the right to bail as a result of bail reform and the increases in crime that it seems to cause?
Well, I can chime in on that. I had the opportunity to be actively engaged in the Kansas pretrial task force that met at the Supreme Court. Former Chief Justice Lawton Nuss had actually implemented and required, and they met over the course of 2 years to look at all aspects of the Kansas pretrial system. And not because anybody was screaming from the rooftops that it was unfair or that there were issues or anything else. It was simply one judge's desire to have it investigated. And so the Chief Justice of the Appellate Court, Judge Arnold Berger, was tasked with creating this group and with investigating it. I always point out anytime I talk about this that nowhere in that entire report, that was quite extensive, does it call for the elimination of surety bail. It doesn't do that anywhere in there, which is great because I think that our state recognizes the importance of that. But there is one section where they do call for further research and investigation on potentially changing the state's constitution to allow for the incarceration without bail. Depending on certain qualifications. So they stopped short of recommending it, but they certainly did call for it to be further looked at. Now, do I think that is that appeals to the Kansas legislature or the people of Kansas? No, I don't, because I believe we know that we have an inherent right pending trial to be released to defend ourselves for various reasons. But it was still called for in that research.
Your thoughts, Judge?
Oh, I agree with my colleague. Bail is important. We should not eliminate it. And, you have to go into the mind of the judge. When he sets bond, we base it up on a warrant based upon what the charges are. If it's I remember setting one for $1 million one time, but it was a double murder. They came in a number of times and wanted some type of relief, did not grant that. They were later convicted. But at each of the proceedings, the preliminary and at pretrial motions, bail was always raised. But you had to look at the history, the criminal history of the individuals involved. And, and in fact, an action was filed against me by defense counsel. And when an action gets filed on a sitting judge, then the attorney general of the state is required to supply us an attorney. And I had an attorney represent me. And basically, there's an old case in Kansas that says you can't go into the mind of the trier of fact, the judge, because his argument was, well, if you make this decision, Supreme Court, this is a Missouri case. He argued a death case in Missouri. If this is the law, then as soon as we're finished here, I need to depose all 9 of you and find out how you come to this conclusion. So you can't go into the mind of the judge who sets the bail or makes a decision in the case. He'll make his findings of facts, he'll make his conclusions of law, and that's what you must appeal on. But you don't get to go and depose the judge to find out how he reached that conclusion. So, but bonding is important. I just looked at some of the other states where their failure to appears have increased dramatically. I like the idea from the suggestion from our Supreme Court about we should do away with cash bail, because at 10% of whatever the bond is set for, most people on small, probably level 7, 8s, and 9 felonies, which are predominantly most of the crimes that are committed non-person crimes, that the bail is set, the bond is set in a low manner that they can afford to get it. There are some cases that the defendant is indigent, and that can be raised at a bond hearing, and the judge can consider that. But he also has, he looks at his past record and what type, if he has failure to appear. That's a consideration that you must make. But I agree with my colleague. The system works, and so why change the system?
Well, and let me make the counter argument for that, for the people that want to advocate that, is one of the arguments that they raise is the presumption of innocence. And part of the idea of that is that somehow bail has a negative impact on the presumption of innocence. Sort of the argument goes along the lines, well, Mr. Smith hasn't been convicted of anything. Why should he have to post bond at all? Now, that's one of the arguments that's made, and I think that relates back to more of a Hollywood version of the criminal justice system. You know, the whole notion where if nobody Mirandizes you, your case has to be dismissed. We all know that's not how that actually works.
Right.
But how does the presumption of innocence play into bail? It's been one of my positions that essentially the only reason you have a right to bail is because you're presumed innocent, not that you shouldn't have to post some sort of assurance that you'll be back from court or back to court simply due to that presumption. Maybe, Judge, if you could expand on the presumption of innocence a little bit and how that relates to pretrial release.
Well, you're correct. There is a presumption in our Constitution of innocence until proven guilty by a jury of your peers. But you've got to remember that a warrant or an indictment that is issued by the court or the grand jury is based upon probable cause. And what is probable cause? What a reasonable, prudent, and cautious individual could come to that same conclusion, that this charge should be filed. So there's a presumption in the law based upon probable cause that a warrant should be issued or an indictment should be forthcoming. So it's just not picking out a name and charging someone. It's based upon sworn affidavits or sworn testimony before a grand jury. So as far as the presumption goes, you're right. You have the presumption beyond a reasonable doubt. However, based upon probable cause, in our Constitution says that an affidavit based upon probable cause or an indictment by a grand jury is sufficient for the charging document. And the charging document, which is normally a warrant or an indictment, sets a bond on it. And then the court, the judge, has to make a decision on what the appropriate bond would be based upon the affidavit. And of course, at all future proceedings, bond can be addressed.
Well, you had mentioned, Judge, earlier also, and I'll kind of lead me into my next talking point here, is that the states that have done away with bail, you referenced both Wisconsin and Kentucky, but also another big one in there is the state of Illinois and the city of Chicago. We've seen, huge increases in crime in Chicago. Even though Chicago has done away with bail, they still have a 10% deposit program, and they've even strayed away from using
Chicago.
So I'm kind of curious, it certainly appears, and we see this in the news, and it's become a real political football here of late, that crime is really on the rise in these last 3 years since these bail reforms or a regimen has sort of kicked in. And while, obviously, crime, both increases and decreases are multifactorial. They have lots of different factors that play into that. How much do you guys think that bail reform is playing a role in bail reform in the form of more lenient release is playing a role in what is really a stunning increase in crime, particularly violent crime? Stephen, maybe you could comment.
I think it's a big contributor. I think the big contributor, I just read what newspaper accounts from New York City where someone's been arrested 53 times for assault, and they kept releasing them. We also need to think about the public, the victims in these cases. Courts make considerations in victims and allows for victim impact statements. But I think the increase in crime in New York and Chicago and those cities that have that no bond or no requirement for bond causes the increase in crime. And I'll ask Stephen what he thinks. I know he's, as chairman of corrections and juvenile justice, he gets more involved in it than I do as Fed and State chair.
Yeah, let me share with you maybe a little bit of information that really speaks to this quite specifically. And this data comes straight out of Harris County or Houston, because that has been a hot topic down there for many years. When a federal judge got involved and said that, you've got to take people's ability to pay in consideration. And so they, in essence, did a 180 in the system and just started releasing everybody, right? And that was about 4 or 5 years ago. And just recently, just late last year, the district attorney that actually advocated for that has completely changed her opinion, because the data is so overwhelmingly clear that when there is zero accountability in the pretrial system, crime increases. I'm sitting here looking at the report that she authored that looks at criminal statistics from 2015 to the end of 2021. Okay. And what we see is defendants on felony bond at the time of filing of a new criminal case. Okay. And this is just one set of statistics. In 2015, that number was 3,538. Okay. So remember, that is 3,538 new criminal cases filed when a defendant was out on a felony bond, back when they used commercial surety and they used the pretrial system. Fast forward to the end of 2020, and that number goes to 11,448. Okay. So literally a 300% increase in new criminal case filings while felony defendants were on bond, because there really was no bond at this point. They were all being released with just a promise to appear in court. The numbers are so clear. They even projected 2021 to end at nearly 15,500. That is 500% increase in new crimes filed when out on bond. So she actually said, look, we tried this bail reform nonsense. We tried taking this into account, and quite clearly, people are less safe now by hundreds of percents than they were back when we used to do it the other way. So it's time to go back to the other way of doing business. Let's bring bondsmen back into the picture. Let's bring the third-party accountability system back in the picture. And we have seen this happen not only in Texas, because Texas actually passed a series of laws in 2021 rolling back this so-called bail reform, but we see them talking about it right now in New York with the new governor is figuring out how to roll back bail reform. We saw it in Alaska. We've seen it just in so many different states where bail reform has failed and crime has increased exponentially, and people are less safe as a result of it.
Well, and actually, let me kind of touch on that some here as well. Now, as you noted before, there are a variety of different kinds of bonds that the courts can use to assure that pretrial defendants show up for trial. Now, but they broadly fall into two different categories. You have non-financial release, which are signature bonds or things along those lines, and then you have financial releases. On a non-financial release, essentially the defendant, I believe, is making a promise that if he disappears, he'll pay some money, notwithstanding how you collect money from a disappeared person. And studies have shown that the Bureau of Justice Statistics has shown that surety bonds have a much better appearance rate than any other form of bond. And essentially the example that you've alluded to in Harris County, those are essentially the equivalent of emergency releases that the federal government knows have a failure to appear rate in excess of 45%. And those numbers meshed out perfectly in Harris County. But if you could talk to us, Mr. Owens, how is posting a bond with a professional bondsman different than, say, simply like in the state of Illinois, posting 10% of the bond straight with the court? I mean, what is it that bondsmen are doing that helps reduce that level of failure to appear that simply providing the money does not?
Well, it's very simple. When people use a bondsman to bond out, they know that somebody is watching them. They know that if they don't fulfill their obligation to the court, that somebody will come after them and will pick them up and will return them to court. When they're simply posting money to the judge in Chicago, they full well know that law enforcement is overextended, underpaid. There are too few law enforcement officers, and that at the end of the day, nobody is going to come and find them if they fail to appear in court. It's proven that 85% of warrants filled by law enforcement are done so at a traffic stop, quite literally by happenstance. Now, that is not to denigrate our law enforcement at all. It goes actually towards the lack of resources that our law enforcement has to affect warrants and to be able to go pick people up. And that's why the private system is so incredibly important, because if we fail to do our job as bondsmen, then we are then responsible for posting the full amount of that bond. Remember, I talked earlier they pay us 10% for us to guarantee the 1,000. Well, if we do not have that defendant in court at each and every appearance, or are unable to locate them within a specified period of time after their failure to appear, we then have to write a check for that $1,000. Okay, now multiply that by tens of thousands, and you get the picture that bondsmen are motivated to ensure that that defendant is returned to custody. But more so, that defendant is motivated. I mean, just think of it from just a purely psychological standpoint. When you know somebody is watching over you to ensure that you go to court and is coming after you if you don't, you're automatically more likely to appear in court. Automatically. And that is the importance of the system that currently exists. So you take that out of it in Chicago, even if they're paying the money, that doesn't matter. You're just creating another fee fund for another government agency is all you're doing in that case, because the same rules apply. It'd be the equivalent of posting an owner recognizance bond where they know nobody's going to come after them if they fail to appear in court.
Well, and then oftentimes as bondsmen, you'll get another third party, a friend, a family member, a member of what they refer to as their community support network to guarantee that bond. So there is a third party out there besides just you that's sort of keeping an eye. And would you say that also helps work as a filter for, who actually gets out on these things? If the family thinks this person is out of control or needs to get off whatever, intoxicant they're on, does giving that control to the family in posting bond, does that help limit the increases in crime we're seeing?
Without a doubt. I mean, there's no doubt. And that's when I talk about that third party accountability system. It is much more than simply just a bondsman. That's a piece of it. But when you do involve the family, you do involve friends, you have them involved in that decision, and also ensuring that they're helping those people get to court, making their appearances. All of those play into a much more successful outcome for the court. But as you heard the judge mention about earlier, the victim of the crime as well. Because at the end of the day, that's the important part of this. Not only accountability of those charged, but the victim receiving their day in court and being able to find closure in the decisions made therein.
Sounds good. I'll try and give a topic here that we can let Judge Barker come in a little bit more. One of the factors that's pretty prevalent in most bail reform issues are so-called risk assessments, basically to evaluate defendants, determine bond amounts and bond conditions, or if bond will be allowed at all. For instance, the state of New Jersey uses a risk assessed regimen to determine whether or not they're even going to release people. Generally, these assessments involve scoring the defendant based on a number of factors, sometimes just 2 or 3 factors, and none of the risk assessments have as many factors laid out as, for instance, in the Kansas statutes on factors the court is supposed to consider. And these assessments have mostly been developed by private for-profit companies and a couple of other anti-incarceration nonprofits like the Vera Institute. And maybe this is a question for you, Judge. Are these sorts of assessments a valid substitute for judicial discretion? And what are the pros and cons of using these sorts of assessments?
Well, this is kind of a new thing, these assessments. I know a number of states that use them. You mentioned Missouri and several other states. And they are developed by a for-profit organization. Most of them, in my mind, are very liberal leaning, but you can use those, but they are not necessarily accurate. Maybe I'm just old school, but I like to be able to look at the defendant, look at his past history, his history of recidivism, how many crimes he's committed in the past, the type of crime, the brutality of the crime, and many of those don't go into a risk assessment. They ask 3 questions and say, well, he'd be a good candidate for no bond. And I've seen those instruments, those tools, but they tell us that they're based on scientific facts. Well, we use risk assessments on a number of other things in the government, on child abuse cases, child investigations. They work 50% of the time. Other factors, it's how much information the individual who's taking the caseworker takes. And if they do a poor job, then you get a poor result. You know, I always want to err in child needed care cases you err on the side of the child. In criminal cases, I want to err on the side of the victim, not the defendant. And I don't want him to get out on a no bond and go back and visit with the victim, even though he may have a bar in his bond. But if you don't have a bail bonding agent watching, that may occur. In fact, I've had it occur in my experience. But to get back to, just want to touch back on one thing that Stephen mentioned, talking about police departments don't have the time to go out and find these folks that have skipped bail or had no bail and skipped their court appearances. I was reading an article, it's probably 2 or 3 years ago, and this was before COVID. The police departments would have to increase their manpower between 10 and 12%. And those 10 or 12% would have to concentrate. Just their job would only be to go out and find people who have not appeared in court. That's an expense to the cities or the counties or the states. With bail bondsmen, they are independent of the court system. They're independent of the state. They have to bear the cost. If they bond someone out with not sufficient information, if they skip out on a $25,000 bond, then bail bondsman has to write the court a check for $25,000. So they take all the precautions. They do tie up all the family members that they can on that bond, because the family members will know where the individual's at. The court system would not do that if the court system did the bond. So that's the reason I've always been an advocate for bail bondsmen. They've brought many people to court in fear of paying the bond, and I always give them an additional amount of time and always ask them, well, do you have a possibility of bringing him in 30 days, 60 days? So we'll have him here in 60 days. Then you have time. Go bring him in. I'd rather have him in court than have your money.
And that's what Kansas law allows right now, right? It's very clear, 60 days.
Yeah. And in fact, I've extended it a number of times.
Sure.
Because they have good leads.
Yep.
And as I say, I'd rather have the defendant than the bail bondsman money.
Absolutely.
Right.
I might touch on those risk assessment a bit, Shane, too. Just
Absolutely.
Share on some of the thoughts from Judge. Risk assessments are only as good as the validation of the inputs, right? People are smart. A lot of people that get involved in the criminal justice system know how to work the system. And if all you're doing is relying on the inputs, then you can forecast exactly what the outputs are going to be on a risk assessment, unless there's true validation. Okay. If they say if a defendant says they've lived at a place for 10 years, how are they validating that? They say they've worked at a job for 3 years. How are they validating that? All of these questions that they're asking without validation are nothing more than in most instances somebody knowing how to work that system. So I've always said that risk assessments, pretrial risk assessments, are an information piece and a piece of or a tool to be utilized by the judges maybe in making their decisions, but ultimately judicial discretion is the key factor, because our judges generally know these people and can see through the lines, if you will.
Well, and as an example, I know that one of the things that bail bond industry has followed up a lot on is they've looked at some of these horrific mass shootings that have been in the news from time to time, and then they've plugged those people into the pretrial risk assessment algorithm, and they've almost exclusively come out with it. Well, this person is at no risk to commit additional crime or no risk to fail to appear, based on whatever factors that the risk assessment used, which really does mean that they're not really a substitute for judicial discretion. It's just a way to provide the court with some additional information about the defendant when they're making that decision.
Right. You're absolutely right. There's no doubt that, like you say, the inputs can equal the outputs. And when you look at those inconsistencies, Idaho actually took it a step further and actually banned the use of these because they've been found to be inherently biased and racist, actually. And they can't be proven otherwise. I believe the law in Idaho was they can only be used if they're proof free of bias and prejudice. And it's impossible to actually validate them and prove them free of those things. So they've stopped using them altogether.
Okay, well, let me address one last issue here, and then we'll sort of wrap this up. The conservative argument for bail reform, a more lenient release, is that we'll save money. I mean, I know that Koch Industries has financed a lot of things, to have people give these talks. I think you actually were involved in a talk at the Dole Institute, Representative Owens, with someone that was making that particular argument. But do we actually save money by releasing people from jail? I mean, most of the time we calculate our jail costs on a per diem basis, but that's assuming that there's a number of people in jail and you can make that calculation. If we lower the number of people in jail, do we actually reduce our costs, or do we just simply raise our per diem rate for housing the people that are there? And Judge, I think you brought up the issue of societal costs associated with increased crime. New Jersey's cost for their program is in excess of $250 million a year that's borne by all the local governments. And in Washington, D.C., and I'm monologuing a little bit here, but in Washington, D.C., the model that the Biden administration is pushing as an example for nationwide adoption is the Washington, D.C. pretrial release program. And they spend in excess of $60 million a year to supervise slightly less than 10,000 pretrial defendants. And that's a cost of over $6,000 per defendant. Now, they like to compare that to incarceration for the whole time versus, hey, if we had some other mechanism of supervising them like bail. So are there steps we can take here in the Midwest to blunt the impact of these policies as they're coming along? As you guys both sit on appropriations and other financially based committees in the legislature, does the state have the money to absorb $250,000 or $250 million worth of supervision costs borne by the state? Are these things that, what can we do at the legislative level to try and maybe just slow down, this sort of, snowballing, boulder of getting us to letting everybody and their dog out of jail?
Well, if I may, the state does not bear the burden of housing prisoners that pre-conviction. Those are county issues. The county must pay that. County jails. Most county jails have a minimum standard of minimum amount of officers that need to work on each shift, whether they have 10 prisoners or have 25 prisoners. You've got to have guards on each of the gates, or jailers on each of the gates. And so in fact, it's probably better if you have a higher number, because that kind of offsets the cost of the 5 or 6 officers that are working. So by having less people in jail doesn't mean you have less jailers. You have a requirement, federal standards, to have a certain amount of guards at each of the sections, and you have to have them separated, the females and the males. So I don't see a cost saving for counties in that area. I mean, if you eliminated your entire jail, you could get rid of the jailers, but that's very unlikely. So I see no cost savings for the counties. As far as the state, since it didn't really get involved in pretrial incarceration, I mean, I'm sure the counties would accept some money to offset the cost of it, but it's not something that I see. And adopting the DC model. Well, have you been to DC lately? I remember during the Ronald Reagan administration, you could go out and walk anywhere. I went out of my hotel one day, and the guy at the doorman said, "Sir, where are you going?" I said, "I'm going to take a walk down to my right, down here about 4 blocks, to get some exercise." He said, "Don't go that way. Go to the left. Go towards Pennsylvania Avenue. You'll be safe. If you go that way, the other way, we may never see you again." And so DC is not a model that I want to a present model that I'd like to emulate.
Yeah, let me jump in here on this. Let's talk first of all about saving money, and then I'll share my thoughts of the state of Kansas. If you really want to look at saving money, then why don't you ask a bondsman how much they're saving the state? Especially if we want to use the same numbers that the state wants to apply. Okay, so we bond out on average. We manage about 5,000 defendants, at any given point in time. You multiply that times, let's say, the going rate of $75 that they like to use, right, of what it costs to house an inmate daily. And then you multiply that out times a year of having defendants out. That's over $45 million a year that just my agency is saving the state of Kansas and the counties. Multiply that times the 400 plus bondsmen that exist in the state of Kansas, and you can see that the true cost savings comes in allowing us to do our job, right? Kansas, the majority of Kansans believe in the principles of limited government and free markets. These are a couple of really the core principles that many of us believe in. And I would ask anybody to ask themselves, does creating a larger government-run pretrial system and eliminating thousands of jobs exemplify the principles of limited government and free markets? And the answer is absolutely not. And that is why I think that we see Kansas not following these other states, not going down that rabbit hole of elimination of private industry to move to a government-run system that is inherently flawed, and why we haven't seen, in the last 2 years, anybody try to bring up bills that affect the system. And quite to the contrary, we've seen the association, Kansas Bail Agents Association, be more involved in being proactive and moving legislation in the other direction to ensure that they can more effectively do their job and more effectively manage these defendants in the event that they do leave the state. So I think the evidence is beyond clear. And I think that the state of Kansas continues to move in the right direction and not follow the lead of the Californias, the New Yorks, the Chicagos out there that simply want to release people without accountability, because we know at the end of the day that costs more on the consumer, on the taxpayer, and ultimately endangers lives exponentially.
So what I'm hearing is, just because they call it reform doesn't necessarily mean it's a positive change for the criminal justice system or the citizens as a whole.
I would agree. It's a fad.
Yep.
It's a passing fad. We have, no data that shows that it works. I would imagine in 3 or 4 years, we will have that data that shows that it does not work. And I'm just not in the mood to join a new fad. You're getting all these liberal prosecutors, the lady in Baltimore who's now in trouble with her own problems. It sounds good. It just doesn't work.
If it isn't broke, don't fix it. And in the state of Kansas, it's not broke.
Right.
I think we've probably covered this topic about as well we're going to cover in this period of time. And I really do thank both of you for your inputs on this. It's been really enlightening on this particular topic. You clearly both know your stuff. And thank you very much for talking to me today.
Certainly appreciate the opportunity to. Thank you, Shane.
Thank you, Shane. Appreciate it.
Thank you.
Thank you for joining us today on the Bail in the Midwest podcast.